Good afternoon, and welcome. The music has stopped, so it's time to start the panel. Welcome to our discussion this afternoon of the new UN Cybercrime Convention. My name is Ken Propp. I come from Washington, where I'm affiliated with the Atlantic Council think tank, Georgetown Law School, and the Cross-Border Data Forum, an organization that promotes cross-border data transfers. We're going to run this panel informally. I will pose questions to each of our speakers, and then at the time at the end there should be plenty of time for questions from you in the audience. This is not the first crime convention that the United Nations has negotiated. There are two predecessors, the first one on transnational organized crime and the second on corruption. These conventions were negotiated in the late 90s, early 2000s. They were relatively non-controversial. They were agreed by consensus, and they are adhered to by virtually all countries in the world. The UN Cybercrime Convention, by contrast, the third in this series, emerged only after a lengthy, difficult, and controversial negotiating process, and we're going to hear about that a bit today. It was completed late last year, and it is now at the point of being opened for signature later this year by countries around the world. So, why did the UN Cybercrime Convention attract heated opposition from a coalition of human rights organizations and large technology companies? How does it compare with the Council of Europe Cybercrime Convention, which has been in existence for 25 years and has long been considered the gold standard for international cooperation on cybercrime? And finally, what does the future hold for the UN Convention, given that it had such a difficult birth? Will it be widely signed and ratified by governments, including by Western governments? There's an open question as to how the US government will proceed in this respect. Or is it a bridge too far in the international criminal arena? These are the questions we will be exploring today with an expert panel representing the European Commission, the Council of Europe, human rights community, and academia. I have on my left, Ignacio Gomez Navarro from the European Commission, Eleni Hickok from the Global Network Initiative, Jan Krelik from the Council of Europe, and Debre Kennedy Mayo from Georgia Tech. So, one of the reasons for the controversy about this convention was that the concept for it, and indeed the initial text, was put forward by Russia. After a long period in which Western countries resisted the idea of a universal cybercrime convention, Russia saw an opportunity, and about 5 years ago they put forward a resolution at the UN which passed. They put forward a text, and indeed the Russian choice for chair of the negotiations was also approved. Russia, along with China, India, and other major countries, are not party to the 2001 Council of Europe Cybercrime Convention. Negotiations began in 2022 and were completed last year after 3 difficult years. They took place in the increasingly contentious international environment that has characterized the UN ever since the beginning of the Ukraine war. What is the UN Cybercrime Convention? It has 3 important dimensions. The first is harmonization of criminal law. It defines a series of cyber-related offenses that must be criminalized in the legal systems of the countries that joined the convention. So they will all have the same offenses in their law. Most of these offenses, by the way, are what are called cyber-dependent offenses, in the sense that they require the use of an information or communications technology system in order to occur. And these are offenses like illegal access to a computer system and interception. It also includes a few offenses that are what are called cyber-enabled. And that means that they can be committed with or without the possibility of an information communication technology system. Examples of these are money laundering and child exploitation. Russia also put forward proposals to criminalize other sorts of conduct in using ICTS systems. These were offenses like terrorism and extremism. They were quite vaguely defined, and they excited quite a lot of concern from many of the countries in the room. There was a long battle over the inclusion of these offenses in the UN Convention that did not end until the very end of the final negotiating round when they were excluded. Russia got support for these offenses from a group of like-minded authoritarian countries, countries that included Iran, Venezuela, and Cuba. However, in order to reach agreement at the end of the negotiation, it was accepted that there would be negotiations on a protocol to the convention. This is supposed to get underway next year in Vienna under UN auspices, and it is virtually certain that Russia and like-minded countries will put these ideas back on the table at that point. A second important dimension of the convention is to prescribe a range of powers and procedures that each state party must put in place to investigate and prosecute cybercrime. So, for example, expedited preservation and production of stored electronic data, preservation and disclosure of traffic data, interception of content data. So powerful tools. Use of these powers and procedures is subject to safeguards that are drawn from international human rights law, provisions like requirement for judicial review, the right to an effective remedy, and the principle of proportionality. Thirdly, and this is an area of great importance, particularly to less developed countries, the UN Convention sets out extensive provisions for international cooperation among parties, extradition of persons, mutual legal assistance to obtain evidence needed for prosecutions, and also mutual legal assistance in collecting traffic data and intercepting content data. And in this area too, mutual legal assistance, there are safeguards, notably a protection against extradition or mutual legal assistance if there are grounds for believing that requests have been made to discriminate against persons on grounds of sex, race, religion, or political opinion. So going after dissidents is in theory, excluded by the convention. And finally, and perhaps of particular interest in a conference like this, there is an article protecting personal data. Transfers are subject to the state's domestic data protection law and to international law and to applicable conditions. And we're also going to touch on that in the discussion. So with that, I'd like to turn to our panelists to explore and assess the UN Convention further. So, Ignacio, the European Commission was an active participant in negotiating the UN Convention. Can you tell us why the Commission thought this convention was a good thing and what its intentions are with the convention going forward?
Yes, many thanks, Ken, for
let me interrupt you for one moment just to say this panel is going to be conducted under the Chatham House rule, meaning that particular statements cannot be attributed to individuals. Sorry.
Many thanks for the caveat. I was going to add myself, because I am here indeed in an expert capacity and not representing the official views of the European Commission. But because indeed I was part of the negotiating team that negotiated the UN Convention Against Cybercrime on behalf of the EU and its member states. The Commission received a mandate from the Council of the European Union to negotiate again on behalf of the EU and the member states this convention, which was a really added advantage, something that added a lot of weight to our role in the negotiations, because we could speak with one voice on behalf of the EU as a whole, but also of its 27 member states, with whom we coordinated very closely throughout the negotiations. So I can say that, as you may have noticed in the recently published the Protect EU European Internal Security Strategy, the Commission asserts that it will propose the signature and convention of this new UN Convention Against Cybercrime. So we are currently working on that, on the proposals for Council decisions that will enable the EU and its member states to sign and ratify the UN Convention. And why so? Because we do think that there is a real added value in the convention and that this is a historical opportunity for the reasons that I will explain. So first of all, as you probably know, cybercrime is spiraling out of control right now in the world. There are some statistics that say that the proceeds from cybercrime would constitute the third biggest economy in the world after China and the US. When you look at the statistics as well, between 2022 and 2023, for instance, the reports on online sexual extortion, which mainly concerns teenage boys and girls, they have doubled. When it comes to the figures of online scamming, if you look at the recent FBI report, for instance, just from one year to the other, there has been a reported increase of 33%. And even according to other statistics, almost 1 trillion euro in the world were lost to international scams. So the fact that cybercrime keeps growing and is becoming an increasing threat all around the world, not just for developed countries, but also for developing ones, we consider that it's a fact. And here the UN Convention can provide real added value. So as Ken mentioned in the introduction, the process was initially launched, indeed, in the UN by Russia and others, and initially opposed by Western countries, by the EU, by the US, and other like-minded countries. Why was so? Because we had the Budapest Convention, and this process, you know how they begin, but you never know how they may end. So initially, we perceived it as a potential threat. What happened is that thanks to our coordinated efforts of the EU, but also with like-minded countries, US, Canada, UK, Japan, and others, we managed to turn what we initially perceived as a threat into an opportunity to fight cybercrime, and not just to fight cybercrime, but also to mainstream human rights into international cooperation in criminal matters. So the two conventions, Budapest Convention and the UN Convention, are often compared, and we still believe that they are complementary, and that the UN Convention will also be complementary to the existing EU instruments that we have and that we will soon have, such as the e-evidence production orders and the e-evidence preservation orders that will come into effect next year. So first, because the UN Convention is a global instrument. Budapest Convention has a vocation, is open to countries other than the Council of Europe members, but it remains not a global instrument in itself. Currently it has 78 state parties, but it's unrealistic to think that it will eventually, all countries in the world will adhere to this convention, and we may also not have an interest in them adhering to this convention because the Budapest Convention provides for more powers than the UN Convention and has less safeguards. So today, it counts with 78 states parties, but there are still 115 states that are not parties to the Budapest Convention, many of which will never become parties, with which there's still a need to cooperate on criminal matters. States, for instance, where some criminal organizations involved in online sexual extortion or scamming are based, such as Southeast Asia or in West Africa. So this is one good reason for the EU to join this framework, to count with a solid framework to cooperate on matters as global as cybercrime with third countries that are not and may never become parties to the Budapest Convention. Second reason is because Budapest Convention was adopted more than 20 years ago. Cybercrime has evolved ever since. And besides codifying the same crimes that you find, so criminalizing the same crimes you find in the Budapest Convention. The UN Convention adds the crime of online grooming that has really become a scourge and that is not currently codified in the Budapest Convention, and the crime of non-consensual dissemination of intimate images to fight against revenge porn. There was just before us a panel on how this is becoming a scourge and a threat, and this is indeed something that will ensure that crimes such as revenge porn are codified all around the globe. So this, we believe that it's added value. And also, by reason of its modernity, made even more explicit the criminalization of the crime of online fraud. So this is another advantage that we see. And this is one of the reasons why some organizations active in the protection of victim rights and children's rights have already told us that they support the convention and they see its added value in criminalizing child sexual abuse around the globe. Then a third reason is because, also by reason of its modernity, the UN Convention includes some procedural measures that the Budapest Convention does not have. There are procedural measures on the protection of victims and witnesses. There are tools for the recovery of proceeds from cybercrime, because as you know, and as I mentioned before, it generates an incredible amount of criminal proceeds that also need to be located, seized, and processed, and be subject to international cooperation, and also other cooperation measures on the transfer of sentenced persons, on joint investigations, on law enforcement cooperation. Then, Ken has already mentioned it, it includes, contrary to the Budapest Convention, a whole chapter dedicated to technical assistance, which was throughout the negotiations one of the most, if not the most important chapter for many countries around the world, because it's already difficult for developed countries like ours to fight against cybercrimes. It's becoming increasingly difficult. Imagine what it is for developing countries. So this convention, and with all the human rights safeguards that surround it, will provide us with a very solid framework to be able to provide technical assistance to developing countries in fighting cybercrime, which is in their interest, but also in ours, because many of the criminal organizations are based there. And then a fifth benefit of this convention, and it goes back to what I mentioned before, that what was initially a threat has become an opportunity to mainstream human rights safeguards in international cooperation in criminal matters. We managed to introduce into this instrument safeguards that are unprecedented in other UN instruments in cooperation in criminal matters and even in the Budapest Convention. So one of them is, for instance, Ken has already mentioned it, Article 6. Article 6 is a scoping provision that says that nothing in this convention, no activity conducted in the convention, whether it is international cooperation, national procedural measures, technical assistance, can be used to suppress fundamental rights. And it even goes on to mention some of the fundamental rights that may be covered and that may usually be threatened by authoritarian states in the digital sphere, such as freedom of expression, freedom of association, or others. So it's a clause that by itself excludes from the scope of the convention potential violations. There's also another safeguard that is unprecedented, that is a non-discrimination ground for refusal. This is a safeguard that you usually found when it comes to extradition, but that you will never find in international instruments, or hardly ever, when it comes to mutual legal assistance. It's a very powerful ground for refusal that allows states to refuse requests for cooperation wherever the persecution seems to be motivated by discriminatory factors, such as political opinions, sex, ethnic group, religion, and others. So this is also a very powerful ground for refusal that we didn't have before in other criminal law instruments. And, of course, a data protection clause, which is the first time that a UN instrument contains a clause for the protection of personal data, and that allows member states to refuse cooperating with other states if such cooperation would entail a violation of their own domestic human rights obligations. So in the case of EU member states, based on the law enforcement directive and the national laws transposing the law enforcement directive, they will be able to refuse requests for cooperation if that would imply a violation of their own data protection laws, and they would even be able to demand additional assurances in terms of safeguards on data protection to be able to exchange with the other countries. So also this is unprecedented, and it's something that we hope will serve as a benchmark for future international instruments or UN instruments in criminal matters. So it is for all these reasons and also others, and also the added effect it has to fight cybercrime, that we consider that there is added value in joining this convention. On the political reasons as well, which were briefly touched upon by Ken, we could also say that throughout the negotiations, it was really a battle for the hearts and minds of the global South. In reality, you had three blocks. You had the Western bloc, you had the authoritarian bloc, and then you had the vast majority of countries that were a bit in what we call the global South in the middle block. And you have them being pulled by each of the sides. And in the end, we managed to convince the global South countries that far from being a nuisance, human rights safeguards were an enabler to international cooperation. So this is why we need to join also the convention to make sure that it's implemented in accordance with its spirit, that its human rights safeguards are well integrated in the systems, and that the protocol negotiations that may follow will not serve, again, as an entry to Russia and other countries to succeeding where they fail, to add additional criminalization provisions into the convention. This is why we also think we need to join. And perhaps I was a bit too long, but I'll be happy to answer questions.
No, thank you for such a detailed presentation. And I think you've given some idea of some of the innovations in the convention. Now, you indicated that the EU is moving forward to sign the convention. The approval process will involve the European Parliament, and there have been expressions of concern that have come from some voices in the European Parliament already about this convention. How do you expect the approval process to go in the EU?
Yes, so I will only nuance the fact that the Commission is moving forward with proposing that the EU joins the convention. So the Commission first needs to come up with a proposal, but then it is for the co-legislators, namely the Council and the Parliament, to give their consent. So first, the Council can approve the signature of the convention by the EU and subsequently by its member states. But then, indeed, when it comes to ratification, the Parliament also needs to give its consent. Now, of course, as you can imagine, we have been regularly in touch with all relevant parties. We regularly debrief the EDPS, the European Data Protection Supervisor, the European Data Protection Board. We're also in contact with members of the European Parliament that were following these files. Of course, they have raised some of the concerns and issues that have been mentioned by some civil society organizations, by some parts of industry, and we have answered them. We will continue doing so. For the moment, we see that there is an understanding of the added value of the convention and also of the value of these human rights safeguards that will mitigate potential risk of abuse. But of course, we cannot predict what the outcome may be. So first we need to come up with a proposal at the European Commission, should be coming up soon, and then we'll launch the whole process with the co-legislators.
Okay, and with that, I'd like to turn to Eleni Hickok from the Global Network Initiative, who I'd like you to explain a bit what your organization does. But I wanted to highlight a statement that GNI put out after the completion of the negotiations, calling for countries not to sign the convention, describing it as a structure for the extraterritorial surveillance and prosecution of human rights defenders, the harassment of tech company employees, and the compelled compromise of systems that protect the privacy and security of users around the world. So strong words, a strong set of objections. And Eleni, could you unpack this a bit for us?
Yeah, absolutely. So thanks so much first for the invitation to the panel. Perhaps I'll just first start with a couple words about GNI. So we are a multi-stakeholder initiative working towards responsible business conduct in the tech sector. We bring together companies, civil society, academics, and investors. Our focus is on freedom, expression, and privacy, and we work to push back against overly broad government mandates that we're finding within legislation as well as in practice. This can include overly broad government mandates across borders for access to data for companies. And so we work with companies to help respond to those in rights-respecting ways. I think at the top, I would say that we absolutely recognize the need for law enforcement to have cross-border access to data for legitimate, necessary, proportionate purposes. But this needs to be rights-respecting. I think also we recognize the frustrations in the existing system for cross-border access to data for law enforcement purposes, particularly from countries in the global south. And we also understand the number of overly broad measures that can be put in place as governments try to get access to data from, let's say, companies based in the US, such as data localization requirements or requirements to register offices or broad criminal penalties for companies, et cetera. So we definitely want a solution for cross-border access to data that is inclusive and rights-respecting. As you pointed out, Ken, from the start of the Cybercrime Treaty, G&I has been very vocal about criticizing the treaty. And not only G&I, I'm also the co-chair for the Freedom Online Coalition's advisory network. We advise 40 governments who are members of the Freedom Online Coalition. And we have also, the advisory network has also been staunchly opposed to the Cybercrime Treaty. And I think, you know, some of the concerns come from the fact that despite safeguards that you outlined, Ignacio, coming into the text in implementation of the treaty, it will result in expansive interpretations resulting in human rights abuse. It will leave human rights at the discretion of the state. The framework can enable or legitimize cybercrime laws that are overly broad. And so just as you noted the rise of cybercrime that's happening globally, we are also seeing a number of overly broad cybercrime legislation coming out across jurisdictions: Pakistan, Jordan, the Philippines, Bangladesh, Sri Lanka. All of these include overly broad provisions that can be used to target human rights activists, dissidents, et cetera. It can be used to block legitimate information. It can be used to put in place direct access provisions for surveillance. And we're also concerned that the framework could be used to pressure smaller states and other actors to give data and make it difficult for them to push back. And so I'm going to unpack these a little bit more and dig into the text of the convention to explain some of our concerns. And you know, just as you talked about how the Budapest Convention and the Cybercrime Treaty are complementary, there are differences between the text. And Ken has a great article comparing these, if anybody wants to get into the nitty-gritty of this. But some things that were concerning to us is about the scope. So we see the Cybercrime Treaty as broadening scope of crimes which could result in over-criminalization. This can be seen in Article 4, which includes crimes in other UN conventions. That's not in the Budapest Convention. We see Article 13 as being broad. And Article 13 relates to ICT systems related to fraud. And then the UN treaty brings in this concept of serious crime, which imposes sentences up to 4 years, whereas the Budapest Convention articulates very core cyber crimes in the text of the convention. We also are concerned about the lack of robust safeguards. So you talked about Article 6 and the human rights safeguards, as well as the procedural safeguards articulated in the UN Cybercrime Treaty, but these are subject to safeguards to domestic law, which we find weakening, ultimately weakening these safeguards and leaving up a lot to the interpretation of implementation. We're also concerned about the criminal liability for companies. We see this as expanded from the Budapest Convention, as Article 19 expands aiding and abetting to include participation in any capacity. And then right now, we don't see effective remedy or review into the text of the treaty. Now, that said, and while we've been very staunchly issuing strong statements against the treaty, at the same time, I think it's important for states to take an approach of high road implementation. I think the effectiveness of this treaty, if it's rights respecting or not, really comes down to the implementation of it. And so what could high road implementation look like? I think states can continue to articulate and promote the rights respecting implementation of the treaty. This could be like pushing for guidelines and implementation. It could be something as bold as naming and shaming states for misusing the treaty. It would be useful for states to confirm interpretation of Article 24.2, that's the safeguards and procedures, that those are obligatory. Continue to emphasize concerns that might exist in the treaty itself and not frame it as a perfect solution. Be prepared to push back on efforts to broaden the list of crimes defined by the convention and through additional protocols. As you mentioned, Ken, this is coming up, and we are concerned that Russia or other actors might try to expand the types of crimes covered by the treaty. I think it will be important to continue to consult civil society throughout the different negotiations, including in drafting rules of procedure. Continue to support in the research into implementation of the treaty. So we are tracking and we are monitoring how it is being implemented. We're finding bad practice, calling it out. I think at the same time, it will be important to continue to focus on capacity building efforts. There are a number, like the GLACI capacity building efforts that are being pursued, and I think it's important to continue to focus on those. And then ultimately, I think we need a holistic approach to cross-border sharing of data across the multiple treaties and instruments and efforts that exist to ensure that these are rights respecting.
I wanted to pick up on one of the points you made about safeguards. You said that human rights would be at the discretion of states. And as an international lawyer, I pause over that because the convention incorporates international human rights law. And it's a basic principle of the international system that international human rights law has to be applied at the national level. There's no autonomous system for applying it. So in effect, what I hear you saying is that you believe that that states parties, some states parties, will act in bad faith and will not uphold their international human rights obligations, even though they're embedded in the convention. I just wanted to be clear, is that your position? And if so, what can be done in the international system other than put international human rights guarantees into treaties?
I mean, so I think that the part of Section 24 where it subjects the safeguards to domestic law potentially weakens the human rights safeguards that are in the treaty. And, you know, domestic law is not necessarily in line with international human rights standards. And so in that way, because there is that carve-out for domestic law, I'm concerned that it opens up questions about the implementation of it.
Okay, thank you. I wanted to come back to this question of the countries in the global south. As Ignacio mentioned, there are some important countries that have not joined the Council of Europe Convention and are not likely to do that, although we're going to hear more about that subject from Jan in a second. So if the UN Convention is a flawed instrument, as I hear you saying, at least in significant part, and these countries are not eligible for or interested in the Council of Europe Convention, but they are in need of international cooperation against cybercrime. Ignacio cited the statistics and the fact that a lot of the spread is in countries other than in the West. How are these countries to cope with a new wave of criminality without a multilateral instrument?
So I think, you know, I worked in India for a number of years, and part of our work focused on looking and examining the MLAT system in India. And India is not a signatory to the Budapest Convention. And I think there are definitely some low-hanging fruit that can be addressed towards helping to make the MLAT system in different countries more efficient. We found issues around language, around legal awareness, around MLAT forms being filled out incorrectly. And so that point that I made on high road implementation, on focusing on capacity building efforts, I think is really important that we continue to try to fix, and also that's part of that holistic strategy towards creating a rights-respecting ecosystem for cross-border sharing of information. I think even with the treaty, you're going to need to be doing capacity building. You're going to need to be figuring out those glitches in the system. I think there are also other bilateral and regional MLATs that can be pursued by these countries. And I think ultimately what we do want is a rights-respecting implementation of the treaty if it is ratified by different states.
So the MLAT system has been criticized for lots of things over the years, for being slow, for not being effectively designed for electronic evidence. And indeed, there are many gaps in the bilateral MLAT system around the world. There are countries that the United States, the country I know best, will not negotiate mutual legal assistance treaties with. How can one go forward with a system based on the patchwork and the slowness of mutual legal assistance treaties? Aren't we better off in a multilateral world with some of these more modern techniques?
Well, I think you also have to be careful in thinking that the UN Cybercrime Treaty will also create that ease and speed of access to data, right? I mean, it might facilitate sharing of data between India and Thailand, but it won't necessarily enable India greater access to data held by companies. Ultimately, I think we need multiple tools coming together to create access to data across borders.
Okay. I'm going to turn now to Jan Kralik from the Council of Europe Cybercrime Secretariat. The Council of Europe has long experience in this area. It has developed a large body of practice and interpretation and has been growing in signature. Jan, your division delivered a largely positive verdict on the UN Cybercrime Convention, calling it a narrow criminal justice treaty that is largely consistent with the Budapest Convention and that contains minimum safeguards necessary for international cooperation, while at the same time acknowledging that some of the concerns raised by human rights organizations and technology companies remain valid. So what are the reasons for the overall support that the Council of Europe has given to this, in some ways, competing or maybe complementary initiative?
Thank you so much for giving me the floor, also for inviting me to this panel. I represent Council of Europe, but I will speak in my expert capacity as a person that participated and followed the negotiations of the UN Treaty. And if I may, perhaps two remarks in relation to the negotiations. Council of Europe participated in the negotiations as an observer, but through our project, we funded participation of experts in these negotiations, and these are joint projects with the European Union, and we're very grateful to European Union for funding of these projects. So this is one important aspect, the participation of experts in UN negotiations. Before, it was diplomats that negotiated the treaty, and now we had practitioners, and this is also something that contributed to the overall result. Secondly, what can be mentioned is really strong and unified voice of the civil society, human rights organizations, and private sector. That is something really that that can be commended and is really unique, and also some concerns that were raised, they deserve attention. So when we speak about the new UN treaty, it's also important to distinguish it from earlier proposals. And you mentioned, Ken, that there were several proposals made by Russian Federation throughout the years. It started, I think, in 2017 with the first draft, and then there were several other drafts. And these proposals, they provided a broad surveillance powers, tools for controlling information. It was not that much only about cybercrime and criminal justice. And really those earlier drafts, they raised serious concerns around suppression of freedom of expression, other human rights, risks. They presented risks to rule of law, but also could cause fragmentation at the international level. But when we look into what was adopted, what is the new UN Convention, we can really see a criminal justice treaty that's focused specifically on countering cybercrime, meaning not on regulation of internet or controlling information or excessively expanding state surveillance. What is important and what's also part of the Budapest Convention and what was then taken, or the inspiration was drawn also for the UN treaty, is that the procedural powers are limited to specific criminal investigations and proceedings. That's an important part. So this is not for intelligence activities, not for general surveillance. And this grounding in criminal justice is essential as it relates really to specific offenses. As was mentioned several times, the core architecture of the UN treaty follows also the definitions and concepts of the Budapest Convention, substantive criminal law provisions, procedural powers, international cooperation. They are, most of them are taken or are modeled by the Budapest Convention. And also what we see as a narrow concept is, for example, the part of the substantive criminal law. We have selected criminal offenses that were part of the Budapest Convention. They have clearly intent standards without right elements. This is all taken from the Budapest Convention. And such as, for example, illegal access, data interference. The vague content-related offenses that were proposed several times, like extremism, spreading of false information, fake news, rumors, they are not part of the UN treaty. The only content-related offenses that we see is children's sexual exploitation and abuse, and also some new offenses that were mentioned by Ignacio, like solicitation of children for sexual purposes, and also non-consensual dissemination on intimate images. And these offenses really, we think, add value to the convention as they are novel offenses that are not found in any other global instrument. With respect to the safeguards, if I may also, because this is an aspect that can minimize the risk that the treaty would be misused. And treaty contains these safeguards that really can or are critical to achieving the consensus. And it's also an important step forward from the UNTOC and UNCAC treaty that do not contain these safeguards. And really what can be seen in Article 6 is an important element. It's novelty that, for example, is not found also in the Budapest Convention, but we also highly support it. And Article 24 is closely mirroring Article 15 of the Budapest Convention. And yeah, there was some polemic that there are some differences. But we consider the reference to obligations under international human rights law as being relevant, as this clearly refers to treaties, but also it could refer to customary international law. So states have these obligations, they have to implement them in the domestic law. And without these safeguards, the treaty perhaps would not be politically viable, and they were important part, really. It's essential for the treaty itself. Now, having said that, we recognize that there may be some challenges in implementation of the treaty, particularly ensuring that these safeguards are adhered to and respected by countries. But from a legal perspective, the treaty, as it is drafted, it sets the minimum protection that is needed for successful international cooperation. And also, Budapest Convention can serve as an example how this can work for the international cooperation. The treaty itself, it also does not compete with the Budapest Convention. We believe that both treaties are complementary. And indeed, there may be some political reasons for some countries. Budapest Convention has currently 78 state parties, but some countries, maybe for some reasons, may not want to join the Budapest Convention. And therefore, the UN Convention may give added value for cooperation with such states. And for some other states, this convention can be just a starting point. And in the future, they may join the Budapest Convention, provided that they continue respecting conditions and safeguards. And then they may also benefit from other tools that are contained in the Budapest Convention framework. The first additional protocol that provides for racist and xenophobic offenses online, but also more enhanced tools for international cooperation under the second additional protocol. So although there are some challenges, as I mentioned, we deem that the treaty represents a targeted international instrument with conditions and safeguards, and that is largely consistent with the Budapest Convention. And states may be encouraged and may want to join this treaty, because not joining this treaty would open the floor and leave it to Russia and its camp. And it's maybe something that Russia also wanted to achieve. And as I mentioned, that what will be important is the implementation. And it may be better to be there, just to prevent that the implementation of the treaty is not undesirable. So I think I would leave it there.
Thank you for that comparative perspective. And I just wanted to underscore something that you said at the beginning about the Council of Europe's role in helping underwrite bringing experts from the Global South into the negotiations. I was also an observer for a good part of the negotiations, and you could literally see the education going on in front of you of the experts from these countries in the potential value of the convention. And indeed, one of the things that happened during the process was that you saw a surge in accessions applications for the Budapest Convention as countries became more educated in the existence of these tools. So I think that is a side benefit from the UN process that's not to go unmentioned. Finally, and I do want to leave time for questions from the audience at the end, I wanted to turn to Debre Kennedy Mayo, who is, among other things, my colleague at the Cross-Border Data Forum and my co-author on a comparative article on the Budapest Convention and the UN Convention. You can find a short version of this in Lawfare, the US blog, and a longer version on the Cross-Border Data Forum website. Debre, do you agree with the conclusion that Jan has offered, that the two instruments are largely consistent, or do you see areas of significant divergence between them?
Well, certainly on many of the aspects, language is taken from the Budapest Convention, or very similar language. So there's certainly a lot of overlap there. I have a PowerPoint presentation for you because I'm a professor at Georgia Tech and have been for 10 years. So I'm going to answer the second part of the question, which is really where are there some concerns. I'm going to answer that at the end, and I'm going to ask the audience to answer that actually by looking at the language itself. So I will just say I'm the Georgia Tech representative this year on the panel. Peter Swire is another co-author that I work with regularly. And for the first time, I have more expertise in an area at CPDP than he does. I've been writing about the Budapest Convention for 20 years, since 2001. So it is an area of concern for me to make sure that we all get it right. It's a very important area to make sure that law enforcement has the access to data that they need for prosecutions and their investigations, and also to make sure that the rights that the individuals, both the accused and victims, have are preserved. So I think it's important to start with a somewhat practical look at this and going back in time to 2019 to really understand how these two conventions are running, not in parallel, but they're running together throughout. In November of 2019, I'm at the UN in New York, and we're having a discussion on law enforcement access to data. It's an expert group. One of the people who is there with me is a federal prosecutor from Brazil. And she has made it her personal mission since 2015 to get her country to do law enforcement access more in line with how the Budapest Convention has been doing. She's trying to get Brazil to accede to the Budapest Convention. Why has she been doing that? Because in 2015, a Microsoft employee is arrested because he won't give prosecutors access to data. And she thinks that that's the wrong outcome, that there should be work happening. So she's trying to get Budapest to be the approach that is taken in Brazil. And she also realizes, because she's a prosecutor with some very significant crime, that they have to make sure that law enforcement access can happen. So she's working on that, and we're at this meeting, we're at the UN, and there's another person who comes up who's from Russia. And it's November 2019, and he said, hey, I have this idea. Would anybody listen? And there aren't a lot of people listening, but by December of that year, a month later, that's when officially the UN starts the long process that gets us to the UN Cybercrime Convention. So this is the other parallel track. This is the big one that people are referring to. While the UN Convention is being negotiated, 12 countries accede to Budapest because they do get education and they do realize that the Budapest Convention is out there. These are countries in the global south that realize that they can go through the process that's needed for the Council of Europe treaty, that the Budapest Convention. So it's a long process, and here, I know you can't really read this, but this is what happens with Brazil in 2019, is they're saying, yes, we want to do this, and we have to go through this process. And so this is the introduction here, but part of what that process of looking at what exists in Brazil is looking at the safeguards and conditions in Brazil. And part of what Council of Europe is saying is Brazil is a party to several international human rights treaties, such as the International Covenant of Civil and Political Rights. Privacy is protected at a constitutional level. And it's important that Brazil be in these discussions because prosecutors and police services have been working to try and make this work for some time. And now the country, the laws are in place that need to be in place to really make it possible for Brazil to accede to the Budapest Convention. So here's the concern again when we look at the two together and what you've been hearing. I want you to look at the language yourself. The Budapest Convention in Article 15 says that for human rights, each party has to ensure that there is an adequate protection of human rights and liberties, and goes on specifically to mention certain international instruments, such as the UN International Covenant on Civil and Political Rights. The language for the UN Cybercrime Convention is in Article 24, and it says not only what you've already heard, that these safeguards are pursuant to domestic law of the party, but also that the party is to act in accordance with its obligations under international human rights. Well, that sounds great if you're a EU member state or the United States. If the country that you're talking about is a country that is non-democratic, and we'll use China as an example, China has signed but not ratified the International Covenant on Civil and Political Rights. So the obligation that they have to meet under international law is not what I would expect out of my country or the people on the panel with me would expect out of the EU. And so here are what other commentators are saying, and we'll start with the Office of the UN High Commissioner for Human Rights. Article 24 of the UN Cybercrime Convention fails to establish a robust binding regime of human rights-based guardrails. Another academic from the EU writes in an article in the Journal of Cyber Policy that Article 15 of the Budapest Convention does provide that robust protection for human rights. So for me, I will say that I've talked with a lot of people who were involved in the negotiations that weren't from the EU or the US, and in particular some people out of Central America. They view the UN Cybercrime Treaty as a way for non-democratic countries and democratic countries to work together related to law enforcement access. And we've heard a little bit about that. That's a good thing, to have some kind of framework. For me personally, I think the Budapest Convention is a more robust framework when it comes to human rights. And so those countries that I showed you initially that had signed on, I think they're focused there. The cautionary tale that some commentators are saying is with the UN Cybercrime Treaty, don't get the expectation in your head that it is going to change the outcome for non-democratic countries so that you're going to see significant increase in protections for human rights. That's not realistic, but that doesn't mean that it's not still a framework that can provide some guardrails. The ultimate question that Ken wants to go back to is, should countries like the United States and the EU, and the complex way that that often happens in the EU, should they sign on and actually ratify the UN Cybercrime Treaty? I think without that, they get left behind in the discussions that will come in the future. And that is probably not a place that we want the world to be.
Thank you, Debray. And she's noted a number of sources that you can look at on this subject if this has whetted your appetite. I hope we've given you a sense of some of the disparities of opinion that exist about this convention, and perhaps some suggestions on a way forward. At this point, I would like to open the room to questions from the audience. You've all been very patient. Is there anyone who would like to ask a question? Theodore in the back.
Yes, thanks to all for a very, very interesting discussion. Just a question. I understand that the EU wishes to accede to the UN Cybercrime Convention on the basis of Article 64, Paragraph 4 of the Convention. And if this is true, do you think that the mechanism of requesting an opinion from the court, Article 218, paragraph 11 of TFEU, might be used, for instance, by the Parliament? And in such a case, do you think that there is any kind of reason, taking into consideration this debate about human rights and the objections raised by NGOs and others, do you feel that there is any kind of risk that the court might find that there is an incompatibility with the fundamental charter and the treaties? Thanks.
Yes, so to nuance, the EU has not pronounced itself yet on the accession. It will only do so once the Council and the Parliament have decided. So what I can say for the moment is that, as the Commission announced in the security strategy, the Commission will propose that the EU joins the Convention. But then there still needs to be the legislative process to follow, where the Council and the Parliament need to pronounce themselves. On the possibility for asking the opinion of the court, well, this possibility, of course, always exists, but it's a possibility that is focused. First, we would need to identify which specific legal issue would be contrary to the EU acquis and to EU legislation in this area. As you can imagine, throughout the legislation, many internal consultations with member states, we have gone through the treaty and we have concluded that there's no incompatibility with existing EU law. It is compatible, and it's even complementary to EU law. The adoption of this treaty will not require the EU to change its legislation or to adopt new legislation. It's, as we say in French, it's à droit constant. So on this count, the risk is that if the Parliament or others were to make such a call, that may leave the EU and its member states completely out of the game for at least 3 or 4 years, or 2 years, because it usually takes 2 years. So in the meantime, there will be a lot going on at the UN. There will be discussions on the rules of procedure of the Conference of State Parties. There will be discussions on the protocol negotiations, where Russia and others will indeed try to get what they failed to obtain during the negotiations of the Convention, additional offenses. And as you can imagine, you don't have the same legitimacy when you have already signaled that you are willing to sign and ratify than when it's already becoming clear that you will not sign and ratify, or even if you do, the prospect is just in a few years. So in terms of the influence of the EU and other and its member states, it could be severely diminished if the ratification or signature process gets delayed for too long, or even it never happens. So this would undermine indeed the implementation efforts, the high road that have been discussed on the EU being involved, providing technical assistance, making sure that in the discussions that the convention is implemented in accordance with its spirit, with its safeguards and others.
Okay, I saw a number of hands. We'll take one right here from the front, please.
Thank you. Interesting discussions. I mean, with regards to the UN Convention, definitely I agree with many of you. I mean, it takes into consideration many criminal, activities that were not actually legislated before in the UN Cybercrime Convention. For instance, also the Lanzarote Convention, which is also another instrument from the Council of Europe, which was barely known among many countries around the world. Well, some of the provisions now are implemented in the UN Cybercrime Convention. What's interesting is concerning Article 56, and this is interesting, the implementation of technical assistance. And this will be definitely a game changer. I know there are some initiatives within the Council of Europe, with regards to capacity and training. Some other, international organizations are doing this, but they are not really sufficiently coordinated. And countries are asking for more capacity building and training so that they comply not only with the provisions of that treaty, but specifically in specific areas like, for instance, darknet, cryptocurrencies, a lot of specific design training. So my question to the panel is, how do you see evolving this Article 56 on the implementation of technical assistance when the UN conventions open for signatures, and how would they complement with other ongoing activities like the ones from the Council of Europe, like the GLACE, all these different projects? Because it's interesting. it's interesting to see many countries are demanding this. And you have clearly put it, that many crimes today are unstoppable, and we need to provide this capacity building, and that's the only way. No matter how perfect the laws or the conventions are, we need capacity building. Thanks.
Thank you for that question. Jan, Eleni, do you want to take a shot at that?
Yeah. Thank you very much. This is very important aspect that has to be taken for the implementation of the convention. And as far as Council of Europe is concerned, the Budapest Convention itself does not contain any article on technical assistance, but this does not prevent us from carrying out a lot of activities. And since 2014, the Cybercrime Program Office of Council of Europe was created, and it has implemented more than 2,700 activities. And the demand really is huge, as you said. It's huge, and we can do it only with some selected countries. We worked since 2014 with around 140 countries, but we focus on the countries that requested accession or are parties to the treaty. But it really, if we could, we would perhaps do even more activities, and we now face even more challenges: artificial intelligence, virtual assets, cyber violence online, and so on and so forth. But to address also your question, how this can be done once the convention is being implemented. And since there is a great complementarity between the both convention, it would be really important to go in tandem with the United Nations and United Nations Office on Drugs and Crime. Just not to coming to that one organization comes to one country and deliver an activity that was already delivered by others. This would not be a good example. So we are also here to offer our support to countries, and also would be happy to work together with the United Nations Office on Drugs and Crime in relation to training of practitioners, legislation, but also in implementation to ensure that the safeguards and conditions under the convention are implemented properly. And what is also important, if I may touch upon one aspect, that's the aspect of monitoring of the convention. Yeah. And as was said, the voice of the private sector, civil society, other relevant stakeholders is very important, and we all the stakeholders should join forces and make their best to ensure that the convention is really implemented as it should be. And this contains also capacity building activities. Thank you.
Do you want to add anything?
I mean, I would just agree with that, and I think it is important to have the capacity building measures in there. I think, that is one of the weak points of existing mechanisms and processes that exist, and I would just re-emphasize that those capacity building measures should be multi-stakeholder and involve civil society. They play an important monitoring role, and they can really spot and document harms in implementation that need to be accounted for when building that capacity. And I would encourage those efforts to build on existing efforts, so we're not creating a really messy ecosystem, but a streamlined one instead.
Okay, we're coming right up to the end of time. We'll take two together, one here and then one at the back.
Okay, so thank you for the answering. My question is a little bit related with the first question, but anyway, I will ask for different angle. Will it be too risky for the EU member state to join the UN Convention before it is clear with the European Union joining to this instrument?
Okay. So a question about sequencing of the EU and its member states, and questions from the back. Let's take that, and then we'll wrap up.
I just wanted to first mention that, well, that the threat just was created by Russia. So, you know, the country with the most cybercrime created that request on the UN, which, I mean, literally state-sponsored. But my question is, like, none of the part discusses the training of law enforcement, which, out of my own experience, which has a lot of contact with law enforcement on this as a service provider, mostly is based on very incompetence. So I would assume that I think the training would be most important before implementing new laws, because the existing ones are often not used or wrongly executed. So I think that would be the most important part. Is there any planning on that?
Okay, so question about training of law enforcement. I'll give our panel a chance to respond to those two questions, and then I know Ignacio has one last comment for us.
Okay, I can maybe very briefly on training on law enforcement. As I mentioned, we don't have a legal basis under the Budapest Convention. This does not prevent us from carrying out the training activities, and we are supporting law enforcement, judges, prosecutors, and also supporting public-private partnership. And as you mentioned, that learning about how to apply the measures, it requires time, and we are really focusing on those specific trainings, for example, on seizing cryptocurrencies and so on and so forth, and how to apply the new measures, and that is something that is important. So it's not only about the legislation, but it's also about empowering the capacities of states.
Ignacio, last word.
Yeah. Yes. So on training, we can only agree, and there are training activities already in the prevention chapter and others, and technical assistance found within the convention. We could build on the GLACY project. On the sequencing, whether it's risky for the EU to join, I think it's riskier that the EU does not join. The current text, we believe it's good. It has what we need. I think I need to react on the Article 24, because there's a lot of misunderstandings on this article, and it was only quoted partly in the slide, because Article 24, it says that the powers and procedures provided for under its domestic law, which shall provide for the protection of human rights. So shall, for all lawyers in the room, you know it's an obligation. This was not in the slide. Shall provide, and this is something that we as EU proposed, and we managed to introduce into this article. It was subject to many lengthy negotiations. So what we have in this article is that domestic law shall provide for the protection of human rights in accordance with its obligations under international human rights law. Why this general reference to international human rights law and not to the International Convention on Civil and Political Rights, EU Convention, Latin American Conventions on Human Rights? Precisely because we wanted to encompass not just treaty law, to which some of the parties may be parties, but also customary international law, so that countries like China cannot say, well, but I'm not subject to international human rights laws obligations because I'm not parties to this convention. Yes, you are, because customary international law, and there's a wealth of it, should also apply to you. So what we find here is simply stating out the obvious, the fact that international human rights obligations are very general in character, and then they're implemented nationally, but the underlying, the main principles, they still have to be respected. And there is a lot of interpretation from international bodies on this. Then on the, I think that was about it. And then, yes, so it would be riskier. Why? Because we have a good text, but as it was said by the other panelists, now comes the implementation, which is as, or if not more important even than the text itself. But if we are not playing the game, if we are not parties to this convention, we won't be able to shape as much the implementation. We won't be able to help countries to do it in the appropriate manner. This is why we need to join the test now, to be sure that it's interpreted as it should be interpreted, in line also with the Budapest Convention, where its provisions were copied, and to counter, to name and shame, to monitor any potential attempt to abuse of this convention.
And I will just say on human rights, the language is not copied. It is an adequate level of human rights from the Budapest Convention, Article 15. There are at least 3 articles in the UN Cybercrime Convention that talk about human rights. And there are many commentators, some agreed here, Others are very concerned, and I will just say that the UN Commissioner on Human Rights has also said there's a concern that it is not a robust enough framework related to human rights. So it is something that is still there, and it is a reason for the U.S. and the EU to stay involved as additional protocols come up.
Okay, well, I think we've given you a good flavor for what the multilateral criminal law system looks like, including controversies that still persist. I wanted to thank our audience for their engagement, and please join me in thanking our panelists.